Our next panel will be about ADR, are we future ready? This topic is particularly near to my heart because this is my favorite field of law, so I will be really looking forward to this discussion, and I can assure you we have the best of people from the field. And also, before we begin, I'll just announce the names of the panelists. Mr. Nakul Dewan, Mr. Amarjeet Singh Chandhiok, Mr. Arush Khanna, Ms. Payal Chawla, Mr. Shreyas Mehrotra, and Mr. Satvik Varma.
Apologies. I thought you said everybody is running late, so I thought.
So sorry, I'm the one who's created that.
How is her? How are you?
Yeah. As I was saying, the topic of discussion for this panel would be ADR, are we future ready? I have a particular bias for this topic. Actually, one of the legal sectors which is very dear to my heart is ADR. Before we begin, I have a question of my own for you all. During the discussion in the morning, we were talking about whether foreign law firms should be allowed to operate in India. And one of the pros of the act was that it would help India become a hub of arbitration, and it would really boost commercial arbitrations in India. So I would like to know your take on that. Moving on, I'll just go through the introductions. We have Sir Amarjeet Singh Chandhiok. Mr. Chandhiok is a senior counsel in insolvency matters, arbitration and mediation. He is a qualified mediator and trainer for mediators. He was a member of ICC arbitral tribunals for international arbitration. He also appeared before various arbitral tribunals of ICC at various places abroad. He represented the Indian government in the Enron arbitration in London. Next, we have Nakul Dewan sir. Nakul Dewan sir is a senior advocate. He practices in Delhi, Singapore and London. He specializes in disputes and international law, advice related to banking and finance, construction and engineering. He has been appointed as arbitrator by the SIAC, ICC and LCIA. Next we have Arush Khanna sir. Arush Khanna sir is an advocate and legal consultant. He is a partner at Newman Law Offices. Arush sir specializes in commercial disputes in the field of arbitration, insolvency, real estate, projects and infrastructure. He has advised and represented several Fortune 100 multinational as well top Indian companies before several courts and tribunals across India. Next we have Payal Chawla ma'am. Payal Chawla ma'am is the founder of Just Contractors, a Delhi-based all-women full-service firm specializing in commercial transactions and disputes, particularly arbitration and corporate law. Payal ma'am has been named as one of the thinkers to watch out for in 2015 by Forbes India. She was named as the Corporate Lawyer of the Year India for 2016 by Corporate Live Wire Legal Awards and Partner of the Year Female by annual IDEX Legal Awards. Next we have Shreyas Mehrotra. Shreyas Mehrotra sir handles the dispute resolution practice including litigation at the Supreme Court, High Courts and various tribunals. He has prior experience in ADR including arbitration, mediation and conciliation. Sir holds close to a decade of experience in dispute resolution and is also a trained mediator. Next we have Satvik Varma sir. He is a litigation counsel and corporate attorney. Prior to setting up his private practice, sir was a partner at India's premier law firm, Amarchand Mangaldas, and also served as the vice president and counsel in the corporate law group at the Lehman Brothers, headquartered in New York. Satvik sir started his career as a litigator at the Supreme Court of India and the High Court of Delhi. While practicing in court, Satvik sir had the opportunity to participate and argue various constitutional laws, insurance and family law related matters. I will leave it to you all.
Good evening, everyone. Can I just get a lay of the land a bit? How many people here are familiar with arbitration? Just a show of hands. How many people have never heard the term arbitration before? Everyone knows? Okay, so let me just begin by a little introduction about the animal we are dealing with. Arbitration is an alternative form of dispute resolution. What that basically means is that parties can opt to have their commercial disputes, mostly commercial disputes, contractual disputes, resolved outside the court mechanism. And this can happen by the two parties mutually appointing a person that they trust or an institution that they trust to resolve the dispute. One of the key elements of arbitration is that the court's power to intervene is very narrow. It's unlike the court's power in a first appeal where they can look at the facts and the law de novo. That can't happen in an arbitration. In an arbitration, essentially, the court can, just to give you a little perspective, can only set aside an award on the grounds that are mentioned in something called a Section 34, which take it as a bias or public policy, something that impacts the public policy of India. Now, in 2015, there were some path-breaking amendments that were made to the Arbitration Act, which are known as the 2015 amendments. These were all geared to making India an international hub. So what that means is that we wanted foreign parties to look at India as a preferred seat for dispute mechanism. Now there have been amendments after that, but very recently, which is last month, we got some more recommendations from the Vishwanathan Committee, and the idea today was to take some of the recommendations that were made by the Vishwanathan Committee and get the perspective of our expert panel to see whether those will actually give an impetus to India becoming a preferred seat of arbitration. So, sir, I'd like to begin with you first. The topic today is, are we future ready? But the question that arises is, what is the future? Should we be looking at India becoming an international arbitration seat? Or do you think, given the amount of litigation that we have in India from a domestic point of view, we should be looking at giving impetus to our domestic arbitration? So if I could just get your views on this.
Thank you, Payal. You should look at the dimensions of this country from Kanyakumari right up to Ladakh. So to say that we'll not have litigation in this country would be, I don't think that's possible even. I see today disputes arising between children in school, disputes arising in colleges and universities, what to talk about other international commercial disputes. So litigation would be there. But the question is India ready for future to be an international hub? It is. I don't think anyone in the world can beat these my friends sitting on my left and right, or any other friends who practice in arbitration. We have done wonders. If you see the statistics of last 5 years in Delhi itself, our disposal rate is far better than it used to be 5 years earlier. It is not that we are not ready, or it is not that we are not competent. It is not that we don't have a place. As I think I met Justice Gupta the other day, 3-4 days ago. He said what is a arbitration at Vasant Vihar. They are getting it vacated now, but by bit, and probably soon we'll start a big international arbitration center there. Now these are all activities for giving us an indication that we are ready for an international hub to be made, India as an international hub. But at the same time, to say that we should not give impetus to our domestic arbitration, I think we need to also strengthen that. And the recommendations that you just mentioned are some of them in the direction, both in the domestic part of it. For example, we are still fighting for years together on venue and place. So at least that recommendation is finally coming. We are fighting at the question now, Supreme Court is looking at whether I can file an application to 29A for condemnation of delay after the matter is over. If the word termination is used in the statute, where is the need for an application to come later? Therefore, the purpose of the object of 29A was that we should expedite our disposals, or expedite our arbitrations. Now, if that is to be lost by giving them another impetus to say, okay, I'll go back to the court and take condemnation, then the very purpose is lost. So we are ready, but we still have miles to go. We all need to put our heads together. And I think, as you mentioned, the committee had very eminent people in it. Some of the recommendations are far-reaching to it. I don't know how many of them will be accepted by the government. In any case, nothing can come in near future because we are ready for elections. So we'll see something in July, August, what can be done. We are all ready. We have strength, we have capacity, we have everything. We only need to have an intent. We only need to be committed, and that's where we should be able to go forward. Thank you.
My next question is going to be to Nakul. Unfortunately, Nakul has a hard stop, and so I'm going to ask him a couple of questions quickly so we can allow Nakul to leave. Not happily, but Nakul, so there's been some amount of conversation about PSUs not being happy, let's say with the quality of arbitrators in a sense, and they PSUs feel that they're not getting their day in court, or before the arbitrator, or their day in court. And there is some diffidence on their part to want to enter into arbitration agreements. And consequently, there's also some chatter that they want an amendment to the Act. The government may want an amendment to the Act whereby the power of the court under 34, they want to expand it akin to a first appeal. So what's your position and where do you stand on this?
Thank you, Payal. First of all, I'd like to thank the organizers for inviting me. And again, to have the privilege of sharing a panel with a senior statesman like Mr. Chandhiok is an absolute privilege along with the rest of the people. Let me just pick this up from, I think, a couple of 2 points that were made earlier. Payal, you began by saying arbitration is done by consent. And that's absolutely correct. If you do not want to arbitrate, don't have contracts which provide for arbitration. You always have state courts to go to. Two, and this is the point which Mr. Chandhiok just made, we're at the cusp of trying to become an international arbitration hub, and we certainly cannot ignore domestic arbitration at this point of time. As we quest and we move along to try and make arbitration a more effective dispute resolution mechanism, we've got to look at both international arbitration as well as domestic arbitration. What does that require? It requires you to strengthen the process. And how do you strengthen the process? You strengthen the process by recognizing the fact that parties have chosen arbitration by consent. No one has put a gun to anybody's temple saying you have to arbitrate. Once you've chosen that by consent, you have then chosen that whatever the arbitrator decides is the appropriate decision which is going to be final and binding. And if that is the choice you have made prior to a dispute, then should you be permitted to then try and open up a whole can of worms after you've lost a dispute and say, let me go to court, let's have an expansive power, because that's really where my remedies lie. Because if that's what you really believe in, then arbitration is not for you. But that is not to say that you ignore a public sector undertaking. I mean, in India, public sector undertakings control a large fathom of commerce. That's the reality of our country. And certainly to turn around and say, well, we should completely ignore them is also not correct. You then have to try and educate them on how to run an arbitration. With my experience, I can tell you that very often officers in public sector undertakings don't take that much of care pre-dispute. That's one of the reasons why they don't get through and they don't succeed with their arbitrations. And that's the reason why they have concerns. So I think if you are able to stem the issue there and you're able to pick up things from there, I don't think it's necessary for us to then go and expand the provisions of Section 34, which is a challenge mechanism under the statute. If we do that, I mean, honestly, it's going to be the sacrilege to the growth of our international arbitration or even domestic arbitration.
And primarily this is because of the delay in the court system, because England has a system where they allow the first appeal, but they have also a regime of coming back with extreme costs if you file a frivolous transaction, frivolous appeal. right?
So there are two facets to this. The first point is that in England, you're absolutely right. You have a challenge on a point of law, but that's optional. So you can contract out of it, which would then mean that the only basis on which you can challenge an award is serious irregularity, which is a procedural process with the court not going into the substance.
Correct.
But speed is certainly the key. I mean, we have to be realistic about the fact that international arbitration or even arbitration is not the only docket the court in India has to have. I mean, Indian courts have a very voluminous docket. There are civil disputes which come before the same judges. You can't just cherry pick arbitration cases out and dispose them faster than other cases.
Just one last question before I let you go, Nakul. There is a proposal that so just for the benefit of the audience here, currently if one of the parties files a motion before the arbitrator on grounds of bias, if the arbitrator rejects that, the party doesn't have a recourse to the court during the arbitration. That can only be challenged at the time of an appeal. But the proposal by the Vishwanathan committee now is to have that challenge right at the threshold, so the parties don't have to go through the pain of a full-blown arbitration. So in that context, I just wanted to know what your views are on this issue. Are you happy with this, or it's going to lead to more litigation in courts and clogging the system?
So first of all, thank you for putting the second question to me and letting me bypass a lot of people in answering that second question. But really, I do have a hard stop, so unfortunately, I have to leave. Does it cause me concern? It causes me significant concern. Now, let's just take a step back. What is Section 13? Section 13 is a provision in our statute, which is that if there's a justifiable doubt to the independence and impartiality of an arbitrator, then certainly a party ought to be permitted to challenge the arbitrator. And it's for that arbitrator, or if there's an institution, for the arbitrator or the institution to determine whether there is a valid challenge. Now, nobody wants to appear before an arbitrator who is either biased or who is impartial. And that's a fair point which our statute recognizes. But you have to also recognize that every intervention in court through the process of an arbitration is like a spoke in the wheel. It derails the process. Now, if you can have a committee which tells you that every court is going to decide a challenge, and perhaps a frivolous challenge, within 30 days of the challenge being made, and be able to stick to that timeline, and if it's an absolutely frivolous challenge or a wrong challenge, it will dismiss it with exemplary costs, because you're effectively attacking the independence of an arbitrator, which you had no basis to do, then certainly you can do it. But will the reality of our court system permit something like that? And the answer is no. And I make that point because, again, you can't take arbitration out and say arbitration cases are the only cases the court needs to hear. It's not possible. So if you cannot do that, any procedure which comes as an intervention is going to then result in delaying the process of arbitration. And if it's going to derail the process of arbitration, then certainly I don't think it's a good step. But again, come back to the first fundamental point that I made. What you have to ensure is that arbitral appointments are independent, and you have exceptionally credible people who are appointed as arbitrators. And you need to have a mechanism for that, so that there is no necessity to really raise a challenge under Section 13.
Thank you for that, Nakul. We are going to we'll allow you to please, we'll excuse you.
Sorry, thank you very much. Thank you very much, and I'm very sorry, but I do have to leave. Thank you.
So before you leave, I would request Dhyani sir to present you with a memento.
Sorry, I didn't want to derail the booking, but can I just take it outside so that we don't derail the... Thank you.
Thanks.
That works. Ma'am, please
One of
continue.
you would like to come and sit? No one wants to sit next to me? No, I don't Wait, I'm just kidding. You don't want to leave, Mr. I don't want to. No, sir, please. Please, anyone. Yeah. Okay, Satvik, the recommendations are talking about alternative fee arrangements. And they believe that if they brought in alternative fee arrangements, this would actually help bring down the costs. So my first question to you is, could you just explain what these AFAs are? And do you think that they will actually help in bringing down the costs?
Thank you, Payal, and thanks Oakbridge for putting together a great first edition of this festival, and I wish you good luck and more grease to your elbow for future events. I think it's important first to understand why the recommendation has come for me to be able to effectively answer your question. And the underlying premise to push for AFAs, alternate fee arrangements, or to have value billing arrangements is because of the fact that the cost of the entire arbitration and the arbitral process, the cost of legal fees, and therefore the overall expenditure has pretty much gone skyrocketing out of the roof and the universe. Some of us as practitioners benefit from it. Most of us are poorer for it because of the fact that it takes away credibility and therefore is not in the long-term interest. So as you, Payal, know very well, what ends up happening, and too bad Nakul isn't here, but while I completely agree with Nakul that party autonomy is key, but the parties also consent to getting into arbitration on certain parameters and expectations which they take for granted. One of which is the competence and independence and inherent lack of bias of the arbitrators. And since we do not have that pool, and as we know from the Delhi Arbitration Week, where several of our sitting judges and some retired said that we need to stop this sort of one-way mechanism of appointment of retired judges. Now, why am I belaboring into all of this when your question is about the fee and AFA? The reason I'm getting into this is to illustrate the point that post the 2015 amendment, we had a schedule, fourth schedule that was introduced, which had a series of fees based on the value of the dispute. It also required that the high courts would set down rules. And it pains me to say and share that except for Rajasthan, Bombay, and I think Kerala or one more, only 3 states formulated those rules, which form the basis of the fee schedule. And the Supreme Court, not only in ONGC and AFCON, but in separate decisions, even had to interpret what the note below the 4th schedule said on the cap and whether the 25% was for each successive amount. Now, these are not matters that we can simply overlook, right? The same famous phrase that don't learn from their past are condemned to repeat it. And that's why I have an aversion towards committees. But on this particular score, I think the alternate fee arrangements where a party knows what is the likely cost, a party knows what is my out-of-pocket for arbitral fee, a party knows the timeline, a party knows the expenditure, or what has been said by the Vishwanathan Committee of value-based billing, which means that they can't be a one-size-fits-all, but either based on the amount of claim and depending on different amounts, there are different parameters. So I really do hope that this gets streamlined. I think it is, unfortunately just one small but a necessary step to streamline the exorbitant cost that has come to get, associated with arbitrations.
Thank you, Satvik. I may just add that the Vishwanathan Committee has actually recommended value billing, which in the report only talks about a capping of the fixed cost. So they're not talking about value billing as it's AFAs are normally understood globally, but they've also recommended that AFAs should be followed by arbitrators, which is quite unique.
And maybe I'm wrong, you're probably closer to the aspect, but what I read also was on value billing, it's proportionate to the time and cost spent.
That's right.
And there were 2 or 3 different parameters that they had given, saying that even qua the cost. So it's a difficult one to explain in limited time, but if you'll give me a little bit of a rope, the entire process, as you know well, of arbitration is to make sure that someone pegs or bears that cost. We are somewhat reluctant in India to award costs always. The Commercial Code Act brought about real cost being given.
Right.
And one of the themes of the Vishwanathan Committee, and I'm using that word loosely, but a theme is that the cost regime should start so that if there is a frivolous dispute or a frivolous litigation, someone is bearing that cost, or rather the loser invariably bears that cost. The loser will bear that cost if he knows that the process was fair. That cost includes the cost of arbitral fee and sometimes even the cost of the legal fee and therefore the overall expenditure. And in that context, my takeaway and read is that the value billing then is that if all of this process is done on, value billing equals time spent over efforts, whatever. I was very bad in math, and that's why
That's why we're all lawyers,
But
Satvik.
yeah, I think
know
I'm,
your pain.
Despite having done M&A for several years, but I think that that's how it was understood, and I actually think that that's a welcome step, because it can't be a one-size-fits-all formula, and we also need to therefore curb it on all sides of the spectrum.
Yes, I agree.
Yeah.
Thank you, Satvik. To Arush, now in the same line of thinking, what are your views on TPF? And is it going, so that's, third-party funding. And do you think it's critical to giving impetus to India being a preferred seat?
Well, thank you, Payal. At the outset, I wish to express my heartfelt gratitude on being invited to speak at this very uniquely curated event and to share the dais with friends and seniors who I have known from my days at law school as well. So really, it's an honor, and it's also endearing to see a nearly packed hall on a Saturday evening. Now, to answer your question, it is indeed true, like you said, that the report has recommended introducing third-party funding into our arbitration regime. And they have recommended so by recommending 2 amendments. One is the explanation to the term affiliate in Schedule 5 is likely to be expanded, and as of now it means any related party. But it will expand to mean that if any party is bearing a cost of an arbitration under a funding agreement, they would also be construed as an affiliate. Thereafter, they are proposing to introduce Section 18 capital A, wherein in case there is a third-party funding agreement, the fact needs to be revealed before the arbitral tribunal during the commencement of arbitration. Now, historically, as most of you lawyers, senior, young law students as well know, that the funding of a litigation or an arbitration by an unrelated, unconnected party was prohibited under the common law doctrines of maintenance and champerty. But, with the passage of time and to embrace modern economic reality, even countries like England, Wales, Hong Kong have diluted and even abolished the concepts of maintenance and champerty and have permitted third-party funding. So essentially, in principle, I think it's a laudable step to introduce it, but and even our courts, I must add over here, even the Supreme Court of India in the famous case of Bar Council of India versus A.K. Balaji and very recently our own High Court in the case of SBS Holdings have upheld the concept of TPF in India. But there is one thing to do the right thing, but it's quite another to do it the right way. Now a third party funding agreement is essentially a contract. So it should be governed by the principles of the Indian Contract Act. But in the context of an arbitration, one must take into account a couple of points which are very important. The rule of confidentiality. Everyone knows that as per section 42 capital A of the Arbitration Act, the confidentiality binds the parties to an arbitration and the arbitral tribunal. That will have to be expanded to include third party funders as well. Now, there are rules of conflict of interest. Now, the Bar Council of India does not prohibit a lawyer from representing both the funder as well as the party. But that could lead to ethical concerns. What if during the arbitration there is a dispute between the funder and the party itself? So the lawyer would know the trade secrets of both the party as well as the financer, which could lead to a lot of issues of conflict, which is not correct. Now, what about regulating the flow of funds? Today, who could be a TPF provider? Who could be a financer? A bank? We need some RBI guidelines on that. It could be an insurance company. We need the IRDA to throw some light on it. What about international commercial arbitration? I mean, we need some FDI policy on that as well. What if there is a Chinese company or a funding from a company which shares a border with India, which needs a government approval? How will all this work out? So I think it is in principle a very welcome step, but if we are to be a preferred seat in arbitration, I think India does need a dedicated regulation, if not legislation, to regulate the concept of TPF in a nuanced and calibrated manner. I don't think it should be a knee-jerk reaction. It will lead to more problems. So yeah, that's about it.
I agree, Arush. Thank you for that. So we have amongst us today an expert on mediation, that's Shreyas. And Shreyas, can you give us a little perspective? We've now got a Mediation Act. So give us a little perspective, some salient features about it. And why do you believe that mediation is the future?
Thank you, Payal. And thank you, Oak Bridge, for inviting me here. It's an honor to be here. Now, what I'm going to be talking about is a little different from the underlying theme of what my panelists have just spoken about. So, mediation predominantly means that there is a human element in the dispute resolution paradigm. What usually happens is that when there is a dispute between the parties either have the option of approaching a court of law, agitating their cause of action, and then having it adjudicated as per whatever the court rules. Mediation, on the other hand, says that if there is a dispute between the parties can approach a mediation center, get a mediator appointed who basically is a facilitator, who will help you to arrive at a settlement, and therefore it will reduce the time involved in the adjudication of the dispute. So now what has happened? So mediation, as from what I may explain to all of you, mediation is a very age-old concept. Like in Hindi we say Razi Nama, and Samjhauta. So that is all a synonym for mediation. So historically what had happened was, in the Code of Civil Procedure there was a section 89. There is a section 89 which said that if the court feels that there is an element of settlement in a particular dispute, the court may refer the parties to mediation. So at that time, mediation was predominantly court annexed, which basically means that two parties go to a court of law and they agitate their dispute, and the court feels that, okay, there is a possibility that you may settle it outside the court, please try your hand at mediation. With the Mediation Act, what has happened is that there is a central mediation authority which has been framed, which has been anticipated will be notified very soon. So the authority basically will be authorizing independent institutions to carry out institutional mediations So a party can straight away go to institutional mediation, they're known as mediation service providers in the Act, and say that there is a dispute which we want to be decided, we want to settle this dispute, so please help us. Now, what the benefits of this is that it's extremely cost effective, and it is also not at all time consuming. So once you go to a mediation center, you approach a mediator, there is a possibility that even complex disputes get settled because the human element is there. So in a mediation, what happens is parties have the option of sitting across each other with the help of a mediator, and they get to understand what exactly was the pain point which led to the dispute having arisen in the first place. And with that, if there is a possibility of a settlement, the chances of settlement are extremely high. So what the Mediation Act of 2023 has done is that it has institutionalized the concept of mediation, and it has also set an outer limit of 180 days. So that time frame, at the max you have to give 6 months to the mediation, and if it gets settled, then you go home happy, every party goes home happy. And if not, then there's also a provision which says that these 180 days will not be counted for the period of limitation. So assuming for a moment that the dispute does not get settled, you don't lose out on the limitation period had you not gone there for mediation. And then one very important aspect which I feel is for the first time coming in a statute is the concept of online dispute resolution. So the Mediation Act says that the mediation can also happen online through electronic mode. Of course, there will be some rules which will come for that. And so that again increases the convenience of the parties. So you can be anywhere in your geographical location and you can participate in a mediation process. And also it reduces costs further, because then the cost involved in going to a place and hiring a particular mediator or all the other costs involved with that are always or are reduced. So that is a very welcome step. So personally, I feel that the Mediation Act is a step in the right direction. Of course, the rules and the nitty-gritties are yet to be finalized because it's a very new enactment. It was enacted, it was signed by the President as recently as 15th of September. So the rules and all the other important guidelines are yet to be announced. So, but it is a step in the right direction.
Thank you so much, Shreyas. How are we doing on time? Just 5-6 minutes? Ten more minutes. Just before I open it up to the audience, I want, we have the benefit of Mr. Chandhiok here, and I'd really like some insights from you, sir. So one of the questions that had come from the lady here was on foreign law firms. Do you have a perspective on whether that will give impetus to ADR?
No, I don't think there's any problem. I said that. I think we are competitive, we are competent, we can meet any challenge that comes from abroad. The problem is slightly different. Unless you bring a legislation to control them, to regulate them, how do you do that? You may invite foreign law firms, they're already existing in this country. Let's be honest about it, one way or the other. So it's not that they are not there. They may not be in my name, they may not be in Satvik's name, they may be in some other name. They're already existing. But the fact is that the Advocates Act either be amended or you bring a new legislation for them so they are regulated. We must know if supposing there's some professional misconduct, then where do you go?
Right.
And see the history of, I'm not going to name people here, one of the largest law firms, the other day I saw 129 matters pending in various jurisdictions. Only on professional misconduct, reported by courts. Forget the other thing that must be pending in the regulator. So therefore I am saying the time has come where we need to open up. There's no dispute on that. But second part, why are they not ready to give us reciprocity? If they are ready to come here and do arbitration, then they want to do, they should give me reciprocity, then I should go there and do it also. In USA, where every state has its own laws, I can't even, if I go to New York, I can't go to California. If I go to California, I can't go to the other state. The rules are different. Therefore, all that must be looked at by us. We need to bring a comprehensive legislation to regulate them. They are most welcome. They can compete with us. I don't think there's any harm in even asking them to appear in court. How does it matter? We'll test our competence there. Where's the difficulty?
So I was inviting a complete contest now. Yes, sir.
No, there's no problem. I don't think.
No,
Look
sir,
at
I'm
my
just
youngsters. They're energetic. They know what is happening in the world. They know what is happening all around in the developments of law. They are competent. They have tools available with them today. It's not that they don't have. Gone are my days when you had to pick up such a big Queen Colonel digest to look at a law. That's gone. But notwithstanding that, we must bring regulation. And I think even Advocates Act otherwise also needs an amendment. There are changes in the society, there are changes in the ethics, there are changes in doing things. Therefore, we must rule with the times that we are faced with. Once we do that, I find no reason why this should not be invited.
Payal, may I just add
Yes,
to
of
what
course,
Sir was
please.
saying? I would actually invite all, young and even senior lawyers to have a look at the Bar Council of India rules, which actually permitted the entry of foreign lawyers and law firms in India. While of course Sir is saying that it's great for us as a profession, but look at the text of the rules. Today we have the rules, sir, that explain the term. So the rules which are under the umbrella of the Advocates Act are explaining the term lawyer and law firm from overseas can practice in India, so long as an Indian advocate is allowed to practice overseas. Now, sir, the Advocates Act doesn't provide for the term law firm. So to say that a foreign law firm can practice in India and to reciprocate it by an Indian individual practicing abroad, on the face of it is an unfair barter. Then they say reciprocity on the country of primary origin. Sir, so many law firms overseas are, based out of 40, 45 countries all over the world. What is country of primary origin? How do you say what is country where the head office is there or where maximum partners are there? So there's a lot left to be changed. Of course, that's not the topic of our conversation. So, but I just wanted to add to what Sir was saying.
You're right, but under the Advocate Act, how could you frame the rules of foreign law firms? It says you have to be an advocate. Advocate should be a citizen of India. A citizen of the United States, you are framing rules under it. How do you frame it?
Any questions from the audience? Yes, please go ahead.
So I have the privilege to have all the stalwarts of arbitration. So recently I had worked on a project. It was a case of Tata Sons Limited versus Siva Industries. In that, the Supreme Court, according to me, it had failed to adequately address or maybe make me understand as to why international commercial arbitration has been excluded from the 12-month time limits under 29. I just failed to, because that leaves literally international commercial arbitration as unregulated. There's no regulation of time. So the arbitrator can take as much time as it wants. Technically, it becomes unregulated. I wanted your views on this, sir. Any of you?
No, it says, the section when the amendment came in 2015 included them. But by 2019, we've excluded them. Not that they can take their own good bit time. They're only saying international arbitration will only be governed by the rules of the country they are. They may be governed by statutory or some other institutions. Therefore, that may provide something else. In fact, there is a conflict in India itself. The High Court International Arbitration Center says 16 months. Therefore, as my friend was talking about mediation, I didn't want to interrupt him to say, every act has got a mediation of its own type. There has to be uniformity. And unfortunately, you're telling in the Mediation Act to say you can challenge it. Then what is the mediation then? So I think the framer of the Mediation Act didn't even know. My friend should go and teach them first what mediation is.
Many of you, most of you in the room may not know that Mr. Chandhiok is actually the guru of mediation in India. He's been instrumental and has been championing mediation as an alternate dispute resolution for almost, I'm near 3 decades in the profession. And Mr. Chandhiok, we all owe a huge debt of gratitude to him for his efforts. But, Payal, as someone who's a New York qualified lawyer, and as someone who, I sat the bar after my master's, I think the discussion needs to also move away from this reciprocity. You also need to bear in mind that the biggest opposition and the hurdle comes from the firms, and therefore the question we need to ask ourselves, which is not me, I'm not the first one who's asking this, is who is acting as the obstacle to this entry, and who, stands to benefit from their non-entry. And I feel that this is, again, in the last couple of decades, it hasn't changed. I think it's the same questions that are getting repackaged in different formulae. And as Mr. Chandhiok said, I think at some level, we've just got to, are not our cricketers playing with so many international cricketers in the IPL, and why do we feel that we're not, up to the mark?
One last question we can take before we wrap it up. Yes, go ahead.
Good evening, everyone. I'm Naina from Insolvency Law Academy. So, when the panelists were discussing that in the arbitration, if the intervention of any other proceedings will come in, so if we will see that if an insolvency proceedings is being initiated and we see that how the claim is being given, so if a party who is in arbitration and if their recovery claim is being there, so we see that how minimal amount they get. Like in the case of, we have seen just the ₹1 was a nominal value as a given as a claim in the arbitration. So what is the lookout for that? That how do we see that how to make it more effective in a arbitration, that such low amount should not be given? Like what should be the way it could be looked at?
So the forum here is arbitration, but just to your point, the recent recommendations are actually addressing some part of that issue. In terms of what they're saying is that if there is an award in favor of a party, then the court should not only encourage the deposit, but the release of that to the other party, to the party that has the award in their favor. And if a party is insistent on that money being deposited in the court, the interest should continue to keep clocking. So I hope that answers your question. It's perhaps not exactly on point. Does anybody want to add something to this?
Well, and please correct me if I'm wrong. I think your question is that when a company, please correct me, that when a company is in insolvency and it also has a arbitration proceeding going on, and if the arbitration award is for 1 lakh, then why is it that the insolvency court only grants 1,000? Was that your question? Can you come closer?
Satvik, what she's saying is that the dispute has been, the notional value is given as ₹1 because the arbitration is continuing. That's what, is that what? Yeah, that's what she's, so I'm sorry, I misunderstood. Right.
And therefore, please continue.
What should be done so that this minimal amount should not be given? Because if other party becomes insolvent and there's a dispute between A and B and the B becomes insolvent, the A will get nothing in hand because the party that is insolvent, they didn't have money.
I know what you're saying, but there's a Supreme Court decision recently that is permitting the claim to continue to be adjudicated separately, even whilst the insolvency proceedings are. So that ₹1 notional value is left for adjudication outside the system of the...
No, the reason for doing that is that once a claim is adjudicated, and supposing the award comes for the CIRP, corporate debtor, then the corporate debtor doesn't get it. A, The person who is a resolution new applicant, he doesn't get it. He gets his clean slate and goes away. That money coming in award goes actually proportionately to the secured creditors whom they have got it. That's why they have put that notional value, not for anything else. No, they are saying arbitration may continue.
Yes.
But what they are saying in the resolution plan, unless the resolution plan specifically provides for it, that if this comes, money will come to the resolution into the company or the corporate debtor. Otherwise, it will go to the creditors proportionately in what they have got it. Whatever, because normally the haircut is so much that they ultimately end up getting the money if award comes in their favor. The new person doesn't get it unless, yes, the award may provide for it. The resolution plan may provide for it. That if they succeed in the award, then they should do it.
I hope that's, yeah. So thank you very much. Thank you, Oakbridge Publishing, for organizing a great event. And thank you to my panelists for their very insightful comments.
We all have a hard stop, that gentleman.
There was,
You had a question, sir? Sorry, I'm Payal, with your permission. I have to run too, but he's been
Raising his
the
hand.
first one.
Myself, Advocate Madhyal from Delhi. I want to know that an advocate cannot fix his fees on the basis of suit value or the outcome of the litigation. But can an arbitrator fix his fees depending upon the value of the suit?
Shreyas, do you want to take that? You've not had enough.
Yeah, there was a mention
Well,
that
the
these fees
fourth
are calculated-
schedule of the Arbitration Act says so. So as long as that's the law, that is what we have
But
to.
can you specifically say that my fees is based on these and these factors and this is the fees calculated?
We're all bound by the fourth schedule.
I think,
This question,
sorry, I'm just, sorry.
This is not permitted for an advocate.
Sir, are you trying to say whether a counsel can charge a fee based on the outcome of the litigation or the
Outcome
arbitration?
and value of the suit property, value of the suit.
No, that you can't. That's, you have to.
But there was a mention that an arbitrator can calculate his fees and put before
No,
the...
the arbitrator is not counsel. Counsel is
no,
representing a
Arush-
party.
There, but many
Yes,
times there
he
are
actually-
advocates also.
He actually has a very good question. He actually has a very good question. His question is...
There are retired
that
judges, there are advocates also. There are
his
doing
question in
arbitration.
simple words, as I understand it, is that if there is a fourth schedule in an arbitration for arbitrators, why isn't there a fourth schedule equivalent for counsel to also charge on a similar line?
Yes, they can't say anything, but it's not permitted.
So
in
the
that.
answer to that is laissez-faire.
This is fair. Okay,
Thank
okay.
you.
Agreed.
and I must tell you, the bar is not Satvik. Bar is not Dr. Singhvi. Please go to the bar. There are people who are actually bar, I consider them, who probably take something in the day to feed their children at night. That's the bar. Please look at them. We need to uplift those people. Therefore, don't go by that schedule fee that Dr. Singhvi charges or somebody charges. That's different. Please look at that ordinary lawyer who wants to charge. Please uplift him. The schedule is for him. He doesn't need to look at the fourth schedule. That's for an arbitral tribunal. He himself may be charging even less than what the arbitral tribunal is charging. So it's not a case that do that. What I'm actually looking forward is that you will one day should be there, as cost is now becoming a rule, that actual costs are awarded if the claim is held to be frivolous, which may be even more than the claim.
Vikesh, can I ask one more question? If you're spilling over, I won't, because I have the benefit of having Mr. Chandhiok here, and
Mr. Chandhiok and I think everybody's here.
So I want to know, honestly, the younger bar is struggling with with payment of fees. There are also a lot of clients who don't pay junior lawyers. You've been the president of the bar, and I want to know if at some level delays can be reduced if lawyers were incentivized to take on fewer matters, but can there be a standardization of fees? Can there be a mechanism where the Bar Council enforces the clients to pay, or is this just, it's not a great suggestion? What are your
Two things. First, to last part of your question. If I file a wakalatnama and I have not been paid the fee, I will not give no objection. And Satvik, excuse my taking your name, he will not accept the brief till he gets a no objection from me. That's a rule already. But unfortunately, we don't follow it. That's the difficulty today. And coming to your younger lawyers, to me, I had made a suggestion. It went. We worked for 15 years for this. We have worked it and worked well. I don't know what's going on today. That every senior lawyer, once he gets designated, must have at least 3 people with him whom he pays a minimum amount so that they can at least meet their requirements. And I saw that it was happening. I don't know today whether it's happening or not. But again, the question is, why can't we seniors stand out to look at those junior colleagues and see how will we help them to come up in this bar? I think that's the only way to do so. We should all adopt this voluntarily. You don't need law. The more you make law, more we'll bring something else and violate it. So law doesn't require, I think we all need, in fact, the members of all of us are covered with the insurance policies now given by the government of Delhi. So the court in a appeal said that, and I said we should frame it. The scheme itself is wrong. Satvik doesn't need an insurance. So please provide insurance to people who have less than 20 lakh or something. Put some yardstick there, whether it's a senior or a junior or anybody, so that people...
And some of the junior members during COVID had...
That's right. We have seen that position happening. And I want to tell you the unfortunate part for us is that we started stamps in the Bar Council. We have not been successful there. So all these are questions of ethics. All these are questions for me and you to understand whom we should elect. Our elected can't be on the proxies that we have taken, or we have taken Bihar or taken Muslims or something. Please bring them on merits. You will see the change in the bar itself. You don't need to do anything else.
Thank you so very much. Thank you for your patience and being a wonderful audience.
I must commend the exceptional depth and breadth of our discussion. The insights shared, spanning from the insightful recommendations from the Vishwanathan Committee to the salient features of the mediation bill, really were insightful and truly enriched our discourse. I would request Dhani sir to present all the panelists with mementos. Beginning with Chandhiok sir. Satvik sir. Payal ma'am. Shreyas sir and Arush sir. I request all the panelists to pose for a group photograph. Yeah, could we please pose for a group picture? Payal ma'am received her memento while she was in the other hall.